President Biden announced that he was instructing OSHA, the Occupational Health and Safety Administration, to exercise their authority they already have under federal statutes to make sure workplaces are reasonably safe for workers, to then issue an emergency rule that would require that large employers require either workers to get vaccinated or go through a period of testing each week. It looks like will be the rule. That sort of press announcement is not itself the rule. It's rather an instruction that OSHA needs to start working to actually make the rule, which also gives the employers notice that, hey, this is coming down the pipeline with details to be determined.
My understanding is that OSHA will implement a system for fines if employers are not following the rule when it comes out, as to the vaccination requirements or testing. And so, the employer might be reported if they are not following the guideline, and then there could be a fine for employers who don't follow it, and then potentially that fine could escalate if there are multiple reports or repeat instances where the company or the job is not following guidelines.
Unfortunately, one of the answers is we don't fully know yet, right? Because we don't have the regulation. The president has directed OSHA to issue the regulation, but we don't have the regulation. So, exactly the details are, are TBD, right? So we're still waiting for them. OSHA does have broad authority to do measures to ensure workplace safety. That's its mission, to provide and to oversee and protect workers. It has a general duty clause that allows it to do that. But exactly what it's going to look like, how it's going to be implemented, the details, a lot yet remains to be seen.
The way OSHA usually handles these things is they put out a standard. They have an army of inspectors that go to the workplace and give citations. Like most federal agencies, they don't have enough personnel or enough funding to cover all workplace, so they check occasionally. Sometimes they get leaks from the workplace, alerts, etc. So it's a combination of active inspector going in and checking, and having information from people in the workplace. In this case, when it comes to do we have a vaccine policy, enforcement might be easier than it seems, because all you have to do is ask the management, are you doing this, either it in place, rather than go in and see what's happening on the ground.
OSHA law developed in the period in which, sort of smallpox was under control and we weren't so worried about communicable diseases spreading in the workplace. And of course, most people, the communicable diseases we were most worried about were either not casually transmitted, see, HIV, AIDS, or people were vaccinated as kids. So, you didn't come into the workplace and spread polio because you all had your polio vaccines as kids. We didn't have a situation like this to the same degree.
For now, we don't really need to wait for the actual content in terms of figuring out whether the federal government can do this or not. I don't think there's an answer that's going to be 100%, we're sure, and it's a bright line rule, because this has really not been done with vaccines before. The times this legal authority has been used have been somewhat problematic. It has been used in connection with asbestos, for instance, and courts have struck some of that down, right? And now we're trying to use it with vaccines. On its face, I think this appears to be legal, because what the law says, look, this is going to be temporary, so we're not going to interfere with the role of the federal government, which usually is none in terms of mandating vaccination. This is a temporary measure. A pandemic is a highly exceptional set of circumstances to be in. So the government is protecting people in general across the country from something that's toxic or harmful to them. The law doesn't go into details about how the government thinks they're going to protect people. So if you think about, okay, it's just about the mission, then there's a number of different things you could be doing. What does the government think it's the most appropriate right now? The vaccination mandate. So from a legality perspective, I think this is how it works. Although this is an informed guess at this point, because the courts haven't really spoken to it.
OSHA has innumerable requirements related to health and safety of workers, everything from ladders to respirators to PPE, protective equipment that is used in hospitals and other settings where you're dealing with hazards. So it's literally thousands of these sorts of regulations that we rely on every day to keep us safe. So those are the precedents, I think, that are being relied on here. I'm not aware of a specific vaccine precedent being used previously.
The federal government has long exercised regulatory oversight of the workplace, right? Again, go back to the 30s when we started having, maximum hours, fair labor laws, all that kind of stuff. OSHA comes in several decades later, protects against workplace dangers of all kinds. We now have a new workplace danger, and we now have a disease that has, and we know it has spread rampantly in some workplaces. And so using the federal authority that has been well established to take measures we know, for example, that, back earlier pre-vaccine, the OSHA there was a lot of discussion about mask mandates and other steps. Why wasn't OSHA doing things to protect workers in meatpacking plants and other places? We spread dramatically in some workplaces. And so I don't think it's a huge step. It feels different, right? But I don't think it's a huge step to say that OSHA uses its authority over workplaces, which is well established, to meet a new threat. And the way to meet the new threat is to require vaccines or testing, right? And there's that alternative. Now, again, the devil's in the detail, and the details may spur litigation, but the idea that OSHA can do this does not seem astonishing, even though it is somewhat different. And again, the federal government has long required vaccines in other areas of its jurisdiction, like immigration, international travel, the military.
The only federal mandate I know of is in this July, OSHA came out with an emergency temporary standard imposing this kind of mandate for healthcare workers. Before that, there was nothing like it.
I would not call it a precedent. You have to specify, this is what I mean by precedent. It's not a legal precedent, right? A legal precedent has to be so close to what you're saying that either you're persuaded by it or you're bound to it. We don't have either. We're not bound to any of this, and it's not close enough because of the difference between asbestos and the pathogen that causes COVID. Or if you think the analogy here is some other type of intervention, then legally it's not a legal precedent because it's another legal tool. You know what I mean? It's a little bit like saying, people, if the goal is, and I'm going to give you a silly example, but if the goal is entertainment, the Cardinals Stadium is visible from my window. If the goal is sports entertainment, I can go to a Cardinals game. I kind of have to be interested in baseball, right? So if the entertainment is I'm going to watch a soccer game for some reason, the goal is the same, right? I want to be entertained, but the method of fulfilling that is very, very different. That's sort of what you have happening here in terms of being a precedent versus not being a legal precedent. So I would shy away from the words because it's loaded and it means there's some case, some law, something that's either binding to us or highly persuasive. I don't think that's the case here.
While the specific requirement is new, it's building on a long-standing power to regulate safety in the workplace. OSHA has been regulating power in safety in the workplace for decades, and there's a long line of litigation that upholds its power to regulate that. And that includes regulating for safety from preventable disease or regulating from safety from other health conditions, such as reducing exposure to cancer-creating agents in the workplace or other dangerous things. So this is not the first time that OSHA has put in place a rule to prevent infectious diseases in the workplace. That has a long tradition. And as I mentioned earlier, already in this pandemic, we've seen OSHA come out with the same kind of standard for healthcare workers.
We also have in other contexts, like in immigration, for example, right now we're requiring, and have for decades, required travelers to the United States to get vaccinated on certain visas. Tourists have not before smallpox tourists before coronavirus have typically not required vaccinations, but immigrants with certain visa types were required to get vaccinated. So the federal government has lots of different things under its responsibility, of course, and the workplace is just another one.
I think the federal government has precedent in terms of implementing various different public health measures, and they usually fall under two sort of broad categories of authority. One is the Commerce Clause, so anything that has to do with interstate or foreign commerce, and that is so broadly construed, so it could be influencing something that is in commerce. One example of that, of a public health initiative, would be the federal government's authority to ban smoking on airplanes. So, domestic flights and international flights, because you're not going to be able to change the law between one state, you're flying one state to the next. You have to be able to maintain the same regulations across states. So that's one example there of a public health initiative, not vaccination, but in another context. The other avenue that the federal government has authority is under the power to tax and spend. And basically the federal government can make funds either contingent on states participating in a particular public health action that they think is necessary, or can incentivize and provide additional funds for states to participate in a particular public health action. And so one example of that might be in the past tying highway funds to raising the legal age of alcohol consumption. And so that was a public health initiative. And, if states wanted their full amount of highway funds, they had to go ahead and raise the legal drinking age. And in the example of sort of giving out funds, even in the vaccine era, they actually do have an example in the late 1970s. I'm going to tell you, let's see, that's the Childhood Immunization Initiative. States were actually given funds specifically to improve vaccination rates and increase the vaccination level for children in across the country. So that was an initiative that was related to vaccines and to funding as well. So the power of the purse of the federal government, if you will, is a really strong way to move forward different public health initiatives. We also have two examples. One from 2 years ago, there was a bill that was proposed that conditioned preventive health services funds on states' school vaccine mandates, and the vaccine mandate that was proposed only had an exemption for medical reasons. That didn't pass. That was in 2019. It kind of ended up just sitting in committee, but that's an example of an attempt at the federal level to take some more initiative and more power over the sort of school vaccine mandates. And then also just a couple days ago, my understanding is that Senator Feinstein introduced a vaccine bill for domestic airplane flights. And again, that kind of falls under the similar purview as the as the smoking ban on domestic flights.
I guess we need to think about a couple of things. One is, need to be clear, we use the term mandate, we're all using the term mandate, but mandates come in different flavors. And at one side of the spectrum is a mandate, such as the one Massachusetts upheld in 1905, that basically says, everybody that the Supreme Court upheld in Cambridge, Massachusetts in 1905 that says everybody who's in this city needs to get a vaccine. Okay? That's kind of a real mandate, or you can face a criminal penalty. The other end are really workplace conditions, and we just need to be clear that the OSHA mandate is, again, to the extent that we know, it's not a mandate. It's not everybody needs to be vaccinated. It's if you are going to work in a workplace with more than 100 people, you need to be vaccinated or you need to be tested, right? So it's a lot of conditions, right? It's not everybody needs to do it thing. And I think that's important to understand as we talk about it.
Some people have, I think, really wisely said it's not really even a mandate. It's rather an option. Either get tested frequently or take the vaccine. Either one, you call it. Which do you prefer? And I think that's really important. There's no question in my mind that an actual, complete mandate could be implemented. But this is really not even that. It's just an option, A or B. Which do you want?
Even though regulating the workplace is pretty routine, emergency standards are not routine. So that's one of the areas where, if I was expecting litigation, I'd expect the most successful challenges, if any, to be on the emergency standard part of it, not on the regulation itself.
The point about the emergency rule is it allows them to bypass the normal Administrative Procedure Act process of waiting for notice and comment. And so it allows them to basically allow a rule to take effect once they issue it.
Emergency temporary standards are rare, and that's in part because the bar for issuing an emergency standard is higher than the bar for regular OSHA regulation. So for a regular OSHA regulation, OSHA just has to show that the measure is reasonably necessary or appropriate to provide safe or healthful employment. It's a pretty loose mandate, not unlimited, but loose. The minus of this regular provision is that they have to go through a lengthy rulemaking process that takes months. An emergency temporary standard can be issued fast, but it has a high bar. You need to show that it's to prevent exposure to a grave danger from specific things, and that it's not just reasonably necessary, it's necessary. That's a higher bar.
So the legal mechanism is the same, right? And we all agree it's a situation that's very problematic for public and individual health, right? But it's fundamentally different, right? Because you have asbestos that we're still to this day exposed to, and it's incremental exposure, and it's continued over a period of time. So, courts took issue with those particular characteristics, because they're saying, look, if we're going to go down that route, then we're going to take issue with so many other sources of toxicity or physical harm. And the role of the state, so this is how the courts were looking at it back in the day and in connection with asbestos, the role of the state is not to protect you from every type of danger, every type of toxic exposure, because we're exposed to toxic elements every single day of our lives, right? It's just, under certain circumstances. And what this legal authority gives the government is the ability to intervene if that danger is exceptional, hence the use of the word grave. So they said, we're very worried about asbestos, just go find the legal pathway that enables you to deal with that type of danger. So the fact that those attempts were struck down by courts, I don't think they speak directly to how a court would decide now, just because asbestos embedded into, literally the fabric of society as it was, very different from a pathogen that causes a spike in an outbreak, and eventually, that outbreak is going to, the curve will flatten. So very different sense of what danger looks like, the gravity of it all, and the appropriateness of the legal intervention. Remember, this is a set of emergency measures. We don't want the government to be too intrusive, in the sense that, if you tell the government, this is going, if you're worried about asbestos, this is the appropriate set of tools to use. Basically, we're saying if you find a problem similar to asbestos, the idea of something being persuasive, you can also use this law, this legal authority to solve that problem. So there's this sort of parade of horrors in terms of intervention of the government, and suddenly the number of things that the federal government can mandate that businesses, people, institutions do, and they said no, you can do a number of things. You can legislate this, you can use property law to do this, you can use other instruments in public health law to be doing this, but it's not the role of the federal government to be intervening. And these are long-term problems, right? We did not fully realize what we were doing with asbestos. Now it's a decades-long problem to dismantle, right? That's not the case with a pandemic. We're talking about a couple of years, hopefully, right? No, not much longer. So the difference is, if you want to do something, for public health reasons, for environmental purposes, normally you don't go to the federal government and say grave danger. Those are longer term problems. The pandemic is a shorter, hopefully, term problem. So that's why it was not upheld, because court said this is not the right entryway into the legal system. The legal system says, you're worried about asbestos, you can mandate certain things, but it's not going to be the federal government, or if it is the federal government, it's going to be an agency after going through a process that's lengthy, that's going to require probably the input of a lot of stakeholders in the process, and then they can issue the proper legal tools, whether it's regulations, whether it's maybe a new law if we go through Congress. But this is not what the administration is doing now. They're saying there's no time for that, right? So the danger has to be, of a spectacular magnitude, and COVID probably qualifies for us to say this is appropriate, because if it's a long-term environmental law problem or a long-term health problem, this is not the appropriate legal tool.
Although COVID vaccines are new, the idea of conditionally requiring vaccination is again, it goes back to the early 19th century, or earlier if you go to variolation, and it is a tried and true, always somewhat contested, always somewhat controversial, but a very old thing. I mean, right, a very old public health tool. And the idea that somehow this is crazy, new, dramatic imposition of un-American, is then America's never been America, because we've just had these forever. And we've had these forever with vaccines that frankly were far, far more dangerous than today. I mean, with smallpox vaccine back in the 19th century, which was not sterile, which really, really did cause a lot of disease. So I just think that we need to keep that in mind.
The federal government is a government of limited power. The main power to regulate public health has always belonged to the states. So a lot of public health action has always happened at the state level. And in fact, if you talk to public health experts, generally a public health response started at the local level, not even the state, because often a public health problem is most noticeable at the lowest level and then spreads out. So most situations are highly localized or state level, and it makes sense for the state to react. That's not as true when we have a national pandemic.
The federal government has not historically mandated vaccines for the general public. They have mandated vaccines for specific populations, like the military, for instance, has a number of vaccine requirements, some that all military members must have, and some that are like location specific, depending on where the military member is stationed. But in general, the vaccination mandates have been at the state level and have usually come in the way of school children having to be vaccinated before attending public school. So that's traditionally where vaccine mandates have been handled. And the federal government has, through the court system, upheld that structure. So that part, has been historically how that has been handled.
Schools generally are governed by the states, although the federal government, of course, spends tons of money, and the federal government could probably use that spending power to mandate vaccines in that domain as well, either among teachers or among employees. It has the constitutional power to do so, and Then the question is just whether Congress has empowered the legislature, the executive to do so. But schools have, under state laws, have had vaccine mandates now for decades, for dozens of different vaccines. And there's been some variation on what sort of exemptions, whether religious exemption or a medical exemption. States have varied a bit on that, but of all the states have had vaccine mandates, and it's just, frankly, not been all that controversial. So all of the excitement around coronavirus vaccines, I think, made some sense before they were FDA approved, when they were still just under emergency authorization. But now that we have an FDA approval of Pfizer vaccine, just like any other, I think we're in a different ballgame here, where this really shouldn't be as controversial.
Normally, the federal government is involved in local or state public health in supporting the local reaction, usually. So they come in with money. If you think about the Flint water crisis, the reaction was local, state, and the federal government came in with money and with water. So they supported the local efforts, but they didn't put in place any broad regulations. In this case, it's, as you're saying, a really broad problem.
The federal government historically has not been the source of governmental vaccine mandates of any flavor. Historically, we've thought of public health law, contagious disease control law as being state law, right? So most of the governmental mandates we have had in the past have come from state and local governments, going way back into the early 19th century, right? These mandates, vaccine mandates, are not new, right? They go back into the 1820s, but they've been mostly state and local. One exception that people have been talking a lot right now, and I want to get back to this, is George Washington requiring soldiers during the Revolution to have variolation, which was a precursor of vaccination. But most public health laws, most vaccine laws have been state-owned, right? The federal government doesn't have this, what we call a general police power. It doesn't have a general power to protect the public's health or to issue mandates, but it does have authority in some discrete but very important and broad areas. And so, for example, the military, right? So I just was mentioning George Washington, that was pre-Constitution. Post-Constitution, though, the federal government has long required members of the US military to be vaccinated for all kinds of conditions. Likewise, the federal government has plenary control, absolute control over immigration. That's not in the area of the states, international travel. It was really common, right, for requiring vaccination for travelers to come into the United States. This is old, this is ancient, right? To be vaccinated against certain conditions. We still require that for people coming from certain areas, for requiring people who are immigrating or seeking visas into the country. They need to show that they've been vaccinated against certain things. And this is not new, right? And if you want to come to the United States and you're visiting from a certain area, you got to be tested for this. You got to have this vaccine. This goes way, way back. It's one of the things the country did once upon a time, long time ago, to control smallpox, right? You couldn't come into the country without being vaccinated. So the federal government has had various mandates in its spheres, in the areas under its control, while leaving, the day-to-day school children in a local city to the local city and state.
The 1905 Jacobson case tells us that the government, the state, essentially can mandate vaccination. But when the court is saying that, and every court after that has upheld that idea, and that's under something called the police powers, which is something that routinely the government exercises. When they were thinking about this, they were thinking about literally the state government, not the federal government. So that controls a different type of measure, legal tool that a certain agent, a certain player in the government can use. So I don't think we have a Jacobson problem here. I think that it's pretty clear that if states want to mandate vaccination, they have that legal authority. That law, that case is 116 years old, and every other case since then has pretty much upheld the wisdom of Jacobson. I think what we have here is a separate legal issue, and it might well, I think it goes, I don't know if it goes all the way to the Supreme Court, but I think it definitely goes to court, particularly when OSHA lets us know exactly what the content is going to be. But it goes through a different set of legal theories and legal problems, so it's not can the states do this, is asbestos was not upheld, that the measures taken in connection with asbestos were not upheld under this temporary authority that the federal government does have. How does vaccination look under that law, not under Jacobson? I think it's a different legal question courts are going to be looking at. I think it's perfectly reasonable from an interpretation perspective for a court to say, what is the problem here? Is it grave danger? Potentially so. I think it is, right? And if it's grave danger, is the measure appropriate? But it's under a different law. It's not a Jacobson problem. Can a state do that? And I think courts will have to answer that question. This other set of emergency powers allow the federal government to do that. I think the answer should be yes, but I cannot promise you a court will view the problem in the same way.
The Supreme Court upheld, saying that there's no individual liberty right that would overwhelm the state's power to do something like this. And for our purposes, that is a very strong precedent even today. If someone wants to claim, no, I have an individual liberty, you can't tell me what to do with my body, that is good law, whether for the state or the federal government. The only difference is the federal government needs an enumerated power to act in this space. And so that's why it can't just require, every citizen to do it on its own. They have to act through an area where they do have power, like regulating worker safety.
The Supreme Court's initial ruling in this area stems back to 1905. You may have heard of the Jacobson versus Massachusetts case. It's a case where Massachusetts authorized local jurisdictions to mandate vaccines, and a pastor, said that he did not want to have the smallpox vaccine. The alternative was a $5 fine, and he also didn't want to pay the fine. And so that case went all the way up to the Supreme Court, and the Supreme Court upheld the vaccination mandate, and said that it was within the state's rights to protect the health, safety, and welfare of their citizens. In the implementation, they have to have a process of linking an individual's behavior to this federal mandate. And in between, we have the employers who are subject to all sorts of federal requirements and auditing processes and things like that. And so we'll look and see how the final rule comes out. We're not to that point yet of the implementation of what will be required. But there's a range of audits and work, and OSHA has the power in some cases to visit workplaces and to confirm that they're complying. And so this is the same process we've used to keep people safe from all sorts of things, from inhaling toxic substances in your workplace. OSHA has to be able to make sure the workplaces are safe. So it really is legally just a question of whether Congress has, whether the Constitution has created power under the Commerce Clause, then whether Congress has exercised that power, which they have in this case, to make sure workplaces are safe, and then whether OSHA has gone through the right procedure of implementing the power that Congress has given it.
And I think the administration was careful, knowing that there would be resistance. I think they were careful not to issue a general mandate, everybody must be vaccinated. They didn't issue an order that states must require vaccines. All of those would have been constitutionally dubious. They took areas of pre-existing federal regulatory authority and put the mandates there. They attached them to areas where there was a lot of precedent that, including, for example, the military, right? Areas where there is clear federal authority, where we assume that the federal government has authority and not just the states, or not at all the states in the case of the military.
Details will be important. I think that constitutionally, these should hold up. There might be questions about statutory construction or something like that could be raised. But the plan so far has been all things that are generally in the purview of the federal government. And so it's likely, if they're tailored, that they'll be upheld. And really this test or vaccinate sort of soft mandate means that people won't be losing their jobs if they decide not to vaccinate. They just have to, participate in this testing protocol. So there is an option that's an out for people who are resistant to vaccinations. And so those are likely to also be upheld as not being too invasive.
It's not, I don't think the question sort of constitutionally about whether there's federal authority here is a serious question. I think what's going to be, more perhaps interesting is it under the OSHA Act? How did OSHA go about doing it? Issues about religious exemptions, but it's not a dramatic shift of federal authority to go here. It's not unprecedented. And I think, OSHA, the federal government has authority over large employers. I mean, the federal government's been regulating employers minimum, since the 30s.